reads of things. This is 2023. There is a minor child is suffering without getting his family pension.
Family pension. When retirement took place?
Retirement minor is a matter related. It was 2015.
When death occurred?
Death occurred in 2012.
Minor child getting pension.
No, family pension.
Family pension.
Dependent
child. What was the age of the child?
Now it is age of 15.
Now it is at 15. All right. Coming week we'll have that. Coming someday.
First recouping method in which they are entitled to get appointment on the arresting order. The state is coming as a petitioner. So let it be listed. Only disclosure by Hon'Ble applicant.
No, they are the dominus lighters, so they are the appellant, you are saying.
Yes, ma'am.
So rehabilitation assistance. So you provide a copy of the memo, it will be listed in the, it will be, all memos are accommodated.
Yes,
but be patient with the list. You see kindly, if you don't listen, then you cannot follow what I am saying. Or if you know it, then you can say that I know what you are saying and you can continue. Since it is just possible that fast anthem may be the hearing matter. So please be patient with the list. Next 2 weeks or whatever way convenient you. And you give a, whenever you are mentioning the, on behalf of the other side, rather when the other side is appellant, inform them.
They should also be ready.
So you give a copy of the memo, get it signed in the your call. It is very simple to do it also.
Yes, yes. May I seek my lordship to make a humble prayer? I am before your lordship appearing on behalf of the petitioner. The matter relates.
All this introduction.
What you want? You want time?
The matter relates with education.
Sir, career of fresh matter. You want listing or you are arguing on merits?
My lord, I may be permitted to present one sentence only. One sentence.
Keep the memo.
No, brother, not like that. Kindly understand. My brother is saying rightly. I'm in full agreement with him. Whether you want motion or you want the get matter posted. That's all.
Yes, my lord.
Posted.
Yes, my lord.
Give it.
Which year? Only question my lord is asking which year it is.
2025. It is
okay. It will get its priority. Fresh matter.
My lord, it relates to relates to NEET examination, which has been published day before, 2 days before.
Sir, you should have stated the fast sentence.
My lord.
Instead of introducing yourself and all these things. 25. When is the counseling?
Within 15 days.
Next week we'll have.
Next week,
Next week.
I may be part
right.
This is a rate appeal which is waiting for the last 1 year. It's a raised admission rate.
He's complete. No, he has to complete. Your brother is saying something.
Defective. Unless you must understand the High Court rules, read it.
No, my lord, I have.
So, return the memo.
No, my lord, it will be listed.
Sir, by judicial order, the defects cannot be removed. Please remove the defects today. Mention on Monday.
My lord, kindly permit me to present one word.
Yeah.
Sir, don't give the impression that we are not permitting you. It is very embarrassing to tell you that when you have not prevented you from doing anything, you are repeatedly saying, I may be permitted. Who has prevented you?
With the governor, I will provide the number.
Don't do that. It is treat the court with respect.
Yes, sir.
Return the memo. This is not the way, sir.
No. Sir, you can comply with the office requirement. Then move a memo. We'll take
yes,
it.
Sir. Yes,
all right.
Yes, sir.
Okay.
Maybe pardon my lord, it's a fresh admission rate appeal matter is pending for the last 1 year. Now the person is around 75 years of age.
Who filed the appeal, sir?
I filed one.
So why you have not moved?
It was moved several times, but not getting this.
No, that's you are giving a wrong impression. Fresh matters, no court is reluctant. You must be seeing daily the performance of the appellant or petitioner counsel.
I'll you want that matter? When do you want?
Monday
may not be some, just see, spread over. Spread over. Many matters we have questioned.
With defect?
No defects.
No. One is after two.
Right, number 40. The last
first a memo mentions for this room, then kindly come to the list.
Okay.
Any other memo?
Any other memo?
Yes, Mr. Bala, item number 40.
in the next matter that regarding registration of
The petitioner is Mr. Mahanta is there.
Yes, sir.
Mahanta, yes, you are taking adjournment.
yes.
Mr. Mahanta,
Maybe, yes, ma'am. No, I have no objection.
when do you want both of you give a date?
29th of
29th of July, maybe. Because the
29th
council for the
of July.
yes.
the council
29th
from
July.
Delhi, my lord.
Sorry?
Council is to come from Delhi, so that is why 29th will be convenient. And
The arguing council comes from Delhi.
yes, and one more prayer can I make?
But in the event on that day when he comes, if you are not ready.
No.
Therefore, if there is any difficulty,
No.
you should inform well in advance your
Yes,
friend,
that-
saying that I have difficulty.
Today also it
That-
is same.
So that he doesn't come from.
From all the way.
Yesterday I also did something I informed.
May I say one thing?
29th July.
May I say one more thing? No, this is at the bottom of the list. Once is
We are not prioritizing, Mr. Mahanta.
Any special reasons for prioritization, except that he travels from
maybe
Delhi?
first item after after notice matter.
To try.
No, wait.
Because
On that day I'll try.
hope see the other mentions. of-
Yes. That matter also I'm for opening once. That matter.
The same matter.
Yes.
Your name is not reflected.
Yes, my name is there.
Yes.
You want,
Do you know
name? I mean, order to be passed.
No.
He's there. He's,
For purpose of appeal and.
I'm
Yes.
I'm talking about 23.
23.
23. I'm for the applying person. So council was taken by any other that the other council will be appealing this.
What is that? You want time?
Yes.
Or you want to argue now only? What is that?
No, your lordship. The council,
Sir, when do you want? Give a date. Look at the calendar.
as per minor
As per my lord is not mentioned there.
Mention some date. Take out, to pull down some date.
maybe July 2nd week.
Huh?
July 2nd.
Second week. At the
Yes.
request.
Second week July. You are for the appellant.
My lord.
Appellant.
My friend is actually from the.
Simple adjournment. We are not passing any order because that unnecessarily burdens the typing.
Yet is not mentioned. Up to 10 matters. Generally, they are not, unless very, very urgent. Any very urgent?
Sir, this not one. Of the 11 old matters, we are not accepting matters. Wait for your turn in old matters.
Old matters, yeah.
So what is the point in listing old matters? To be adjourned.
Because no,
Kindly wait, sir. If you have any difficulty.
We'll accommodate also. Please wait. But basically, we are against adjournment. The underlying point is we are against adjournment.
Wait, sir.
Yes.
So the order has to be passed. We can't pull out a file and start dictating because Mr. Sahoo is appearing.
Let us see.
Yes, next. Yes.
Your Lordship, I have a memo to mention, Your Lordship. Maybe pardon, Your Lordship, it's an appeal filed by the state, Your Lordship. I got the consent. Your Lordship, the matter is pending since 1 year. The order
2
was.
weeks after is possible for you. Any difficulty 2 weeks after?
No, Your Lordship.
Later 2 weeks after.
Inform other side also.
Yes.
Item number 34. I'm for the respondent.
Item number?
I'm for the respondent.
It's a after notice matter, you inform the. We are just simply marking
from the appellant.
You are for the respondent or appellant?
I'm for the respondent.
So appellant, you have
If
to.
they can consent.
No, consent is your, I mean, private realm, we are not party to that. Please appreciate that. Then we'll mark that because you will come and complain that the matter has been
The
adjourned.
counsel of the appellant is mentioning in a different court. This is
Different
what.
court.
So let him come.
Please wait.
Whom you have
Please.
informed? Whom you have informed? Name of the council? Appellant करो ना council करो ना कौन? जाके inform करो.
There is a Satyajit Mahapatra.
You are too tentative. I think you will never talk to him.
We'll accommodate.
Come on, definitely. You are Mr. Singh. For respondent, you are for. Your name is
I
not there.
am the respondent. My name is Jyotirmay Barik. J. Barik is there.
When do you want?
Second week of July.
No, second of July, so many matters, sir. The third week.
Yeah.
Old matter, I don't know one.
Still pending. That main matter, CMPAT, number so and so is still pending. In this regard, a report obtained from CISC is at flag BC. It is pending. Any interim order?
For the appellate.
Appellant.
Already studied, it was in the board. Alerts was directed, they along with the 25 of 2001 to be listed. And no one has also for the
Appellant. Any interim order was there against this order in challenge. Otherwise, no purpose will be served. The main matter is pending.
Exactly.
And the order 43 rule 1 capital A of CPC is applicable to these proceedings. Therefore, even interim order can be challenged in the event the main matter goes against him. Take out order 43 rule capital 1A, amendment 1976 amendment. The right to challenge non-appealable orders in appeal against decrees. When any order is made under this code against a party and a decree and thereupon the judgment is pronounced against such party and a decree is drawn up, such party may, in an appeal against the decree, contend that such order should not have been made and the judgment should not have been pronounced. A. Ramayya company law says this provision is applicable to these proceedings. Whatever order, this is following old Bombay High Court judgment.
But this order regarding OTM, what is the textile mills? Then is that the knowledge that no longer surviving? Maybe there are a batch of company petitions. Somehow one is language. Okay.
It was under the Sikka.
Long back OTM was disposed of. 10 years
And in the meantime, 10 years before it was by the BIFR, always in the AIFR also, appellate authority. Then subsequently, another tender was there, it was possibly.
No, that main matter is still pending. What we propose to do is, there is no stay order or against this, na? No stay order. Then what we can do is, let him challenge this order in the event main matter goes against him. First time. Therefore, will not interfere on this. But this is improper. This intra-court appeal seeks to call in question a company court's order that topic, which page 43. Order dated 6/3/2006 in Company Act case number 25 of 2001, confirming the order dated 25/8/2005, whereby the sixth respondent is permitted to remove the plant and machinery from the subject side along with the existing structure. First off, there is also a further direction for retendering the sale of the assets of the Orissa Textile Mills Limited into brackets now in liquidation with a condition to run the industry. First off. Next paragraph. Having perused the appeal papers, we are not inclined to grant interference in the matter in as much as the order in question can be subject matter of a challenge when the pending main matter is decided against the appellant herein. On the line with the provisions of Order 43, Rule Capital 1, Capital A of amended CPC 1908. First off, no extraordinary reason is shown to us as to why that course cannot be adopted. First off, next paragraph. This apart, the above apart, the office objections are also not addressed.
At least, despite listing yesterday and today.
Despite a long lapse of time, nor there is any explanation for such culpable non-compliance. First off, that gives a legitimate impression to the court that the appellant is not interested any longer to prosecute this appeal. First off, next part, in the above circumstances and with the above observations, this appeal is disposed of. First off.
Still yesterday, program further object to yesterday.
Above? Despite? No, above that. Address despite giving opportunity. Opportunity. Okay. In the above circumstances, this appeal is disposed of with the above observations. Okay. Yes.
Item 2. Item 2, my lord, I am appearing on VC, my lord. There's no instruction on this matter, my lord.
No, you can't say instruction. You are not going to cross-examine anybody here. You have to argue the appeal on merits.
Yes.
It's an appeal. Say some other ground.
My lord, I'm not, I tried to contact with the my lord the appellant, but my lord.
Appeal is on record.
My lord.
Appeal is on record. You should argue the matter on merits as it is. You will argue it next week.
CP is not surviving.
CP is not surviving. Why main matter is gone?
But are you aware the CP is disposed of long back on?
Was disposed of for 16/5/24.
No, my lord. My lord, the brief actually is not available with us, my lord, since we are trying to contact with the appellant.
I will give you liberty. There is a report from the registry saying that main matter itself is disposed of. This appeal calls in question the company court order dated 6/5/2009 entered in then pending CP number 5 of 2009. First off, the registry has reported that the said CP has been finally disposed of on 16/5/2024, and therefore, in our considered opinion, this appeal has become infructuous. First up, calculate below. In the above circumstances, the appeal is disposed of accordingly, keeping open all contentions of the parties that may be urged in terms of 43 Rule 1 capital A of amended CPC 1909 in the event order whereby CP is finally disposed of is put in challenge. First, in that connection, all contentions are kept open. Okay.
So his name is, what is your name?
My lord, I'm appearing on behalf of Mr. Satyajit Mahanti.
Yes, you are not looking like him in mobile phone. That is why I'm asking, what is your name?
My lord, because my power is not that it's an old matter, my lord, for that is the reason, my lord.
Speaking of a matter, we have to record that who is present.
My lord, my lord, my name is Devi Prasad Sahoo, my lord.
Devi Prasad Sahoo on behalf of Satyajit.
My lord, much obliged, my lord.
Expedition number 2 of 2000 is so and so. Objection to MC so and so. Well, this there is no report from the registry as to whether the main matter is still pending or not.
Tuesday. Maybe they could not verify.
Call this matter on Tuesday instead. And in the meanwhile, registry to secure authentic information as to the pendency or disposal of MC, that is CP number 2 of 2012. Well, first stop.
Mr. Mahanti, what is, you are sitting quiet? I didn't notice you. This is your petition. Yes.
The brief has been already taken by the client, the appellant.
Well, at least should you not stand up and tell us when the matter is called? No, you should tell us. Yes. At least when matter is called, it is required. Sir,
The matter is called about item 3 document. In VC also they say that your voice is not audible. Please call the matter when. Yes, Mr. Mahanti, you say that. So what is to be done?
Your lordship may stand notice.
No, they can't plead no instruction in appeal. Except
No, are you aware that any yes, Ms. Modi, the main petition?
As far as to my knowledge, the client has last night he had visited to the chamber. He said the matter has become infructuous.
Infructuous. You are for appellant.
I'm for the opposite part.
Learned opposite party. Why it has become infructuous? He may say all that, but how?
Well, no, we don't have any file.
Do you dispute that it has become infructuous?
No, I don't do.
You don't dispute.
No.
But both the sides appearing for the respective parties on being asked in all fairness submit that the list in question has become infructuous and therefore appeal be disposed of accordingly. First time, ordered accordingly.
So P.K. Mahanti for
And the appeal is disposed of.
P.K. Mahanti for appellant, S. Modi for respondent. Item 4.
Same, my lord.
Same order. 3, 4, 5 same orders. Yes. Thank you.
If it's not removed, not taken. It will be removed.
It will be removed. Prashant Kumar Mari.
Instead of PF, no one was attending.
Nobody appears for the appellant.
Snow Kumar fine.
That is, someone was present said that I am appearing now for EPF organization.
Was Snow Kumar fine there?
Why nobody is interested in the profession? Interest is diminishing.
Now it should party is the DOSG. So, he is the DSTI now.
No,
I am a senior fellow counsel, gossip for me, special.
you will.
Oh, do you have instruction?
for their own
Party's
body.
stand is that you can no more appear for EPL. We are not sure, so be sure of what you are saying.
Whether the President may kindly post the matter to tomorrow, so
Tomorrow
on Monday.
you have to take separate list from the Honorable Chief Justice. You want judges to work even on Saturday?
I apologize, madam.
Some humor in that fault. Nobody should be tense. So humor is the best way. Yes. Call this matter. Next week we'll have it at your request.
Pass over, then he can. One chance may kindly be given.
Your friend is saying something.
Passed over. Take the instruction from Paddy.
And it will call next week. Sri, so. Though he is not an advocate on record, seeks 1 week accommodation to make arrangement for representation for the appellant. Call next week.
Item 11.
Yes.
Connected case, my lord, I am appearing for the petitioner.
2 cases are there.
My lord, one is the
Yes, sir.
This fellow, the order of the appellate authority is page 21. 81, annexed form. Page 81.
81.
81.
Can you make a brief statement? We call it as Brandeis statement in the American Supreme Court.
Well, what happened?
1 second.
A service of the.
Hear me.
Yes, I have 2 lines.
Hear me.
Yes.
Hear me. You don't want to hear the judge?
No, definitely.
There are many who will hear.
I'm there.
There was one Justice Brandy in US Supreme Court. He was a great lawyer. Brandy used to open the case with the 2 sentences
Yes.
in such a way, so beautifully, that we have to develop that art also. A sort of advocacy.
That I want to do.
Very well.
This.
Do that.
You make
Or
it
all-
one sentence.
No problem.
I will make it in 1 sentence only.
Whatever we say is not only for you. There are youngsters in the court hall.
The appeal against the termination of the respondent number 4 here
From service.
from service was dismissed by the appellate authority on the finding, because objection was there that no such appeal was ever been filed in time, because there is a period of limitation. And on verification of the record, appellate authority dismissed that appeal because it was not there.
No,
The
how he
single
could, 1
judge-
second.
Sir.
How he could dismiss an appeal which was not there?
No, because there is a direction from this honorable court to decide that representation. The very technical way that person has come to this honorable court with a fictitious petition that my appeal is pending before the appellate authority. And this court on bona fide belief at the stage of admission dispose of that case, directing the authority to decide that appeal in accordance with law. So when it was confronted by the management, by my client, that no such appeal was ever been filed, because the appeal was to be filed within 30 days. It has not been filed, and the appellate authority, has being a quasi-judicial authority, has no power to condone any delay, as per the judgment of the Honorable Supreme Court matter. So it was confronted. And on verification, he came to a conclusion that yes, no such appeal was filed, therefore he has dismissed that appeal. Against that, writ petition was filed by the respondent of 4. In the writ petition, the Honorable Court, without even calling for the records or the fact finding on the record,
Who is for the
directed that
All right. Who is for the employee?
employee is the first time it has
First time it has come.
Yes, it has not. But my lord, my difficulty is, my lord, though it is I have tried my best to get the listing. The case is posted in because it has been remanded back. Order has been set aside. and remanded the appellate authority to decide on
There
merit.
is no appeal at all.
No,
So now
only
case is
one-
posted to tomorrow. No, sorry, I'm just showing
only
the
one sentence from us.
Yes.
So did you show that the learned single judge that there is no case filed, could not have been dismissed? Or either way?
I can't prove.
What was your stand before the learned single judge? You
I'm not single judge.
you are for the dismissed employee or for the...
No, I'm from management.
You're for the management?
Yes. My simple case before the honorable single judge was, since the appeal was not there and the power of the appellate authority is also not there to condone any appeal.
Where is your objection?
That counter I have filed, that is at page 84.
84.
Yes, before the honorable single judge. And the objection to the appeal before the appellate authority is also attached there.
Where is that contention? No appeal is filed.
My. That is also taken in by the order itself.
No.
The impugn order.
In your, not that. In your objection statement or affidavit, where have you stated that no such appeal is ever filed?
You are
But by right.
The repetition is 25380.
Yes. Tar counter.
I don't find any counter.
Yes, yes. I annexed that. Page 84. Counter has been taken note of.
Court's repetition.
Court में अच्छी तो court ने order रे my lord have concerned.
Right, you have stated.
Yes. All through the I have this is stand, but it is more with the document I have stated. That is furtherance to the preliminary objection. The college has sought for information that from the directorate to one of its employees, Mala Swine librarian, and it was ascertained that no appeal recommendation dated 4/9/19 was received in the directorate. The director has also issued notice to the governing body and the principal of the college, only with the reference of WPC 6463 of 23. Therefore, the petition has taken delay in filing the so-called appeal before the appellate authority by referring to the judgment of the Honorable Supreme Court in the case of.
So it's a sign. So in law has been settled that one judicial authority has no power to condone them. There's an objection of the was due to filing the petition of 5/9/2019. Penalty order is dated what?
6/8/2019.
6/8/2019.
It was filed by 5/8/2019. As per the government notification or circular, it was to be filed in 30 days. That means 5/9.
5 is which Sunday, Saturday, some holiday.
No, it was not there, but it was a working day.
Yes. How do you say that?
From the calendar.
You can't say that. Only
I have verified the calendar.
Shakuntala Devi alone can say that, not you.
I got a man which contains 100 years calendar.
On
I
that
got
basis.
it on my table itself. I have.
Okay.
If my lord want that, I can give it more.
We'll believe you. There is no reason to doubt.
So now,
Understood.
yes.
Still you want to argue?
No. Page 126, para 8.
Where is you are for the respondent?
No. It is state.
Your state. Let notice go. Because appeal has to pend to pass an order on that. And appeal means one filed within the period of limitation
30 days.
where there is no provision for condonation or delay. That is his argument. Issue. Emergent. Whatever. For standard format. You serve copy on the counsel who represented the respondent in the court bill.
I know him. If you will accept, I will give.
The learned counsel for the appellant is requested to serve a copy of the appeal memo.
He may not.
1 and 2.
Okay. Shri Mahanti, learned EGA, on request accepts notice for the respondents 1 and 2. First off, emergent notice to the third respondent who is the contesting party, employee. First off, it is open to learned counsel for the appellant to serve a copy of the paper book on the counsel who represented the third respondent before the learned single judge. First, this he has to do very fast.
Anyway, because the case is posted for the director on 21st. I have got a notice. Tomorrow, my lord, it is posted.
Okay. In the meanwhile, all further proceedings pursuant to order of the learned single judge are kept at a bay.
Published. नहीं straightforward and urgent copy की तो तुम्होंने तो date and produce और it is uploaded मतलब
Today only.
okay
We are assigning all orders same day.
right
I don't have
Some long orders we take time, but these orders we pass same day, we sign also. Yes, sir.
Well, it is a case of re-engagement. As per the earlier order of the Sahoo code, whenever any vacancy arises, informational shall be considered against the post of driver. So, as per the direction, I sought the information under the RTI that vacancies are available. So, my case may be considered as per the earlier order of this Sahoo. But the impugned order in this before the single judge. Whether the government will approve the post or the municipal corporation will approve the post. So it was a case.
My government will.
The Cuttack Municipal Corporation sent the proposal to the government. Housing and
You want promotion?
No, my lord. Re-engagement.
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 What is that? Right to re-engagement arises under which law?
My lord, I was working under the CMC for a certain period. And
What is that period? From which what date to what date you worked?
My lord, 97 to 2000.
You have to give the date. 97 to 2000.
2000.
Only 3 years.
Only 3 years, my lord. So, because of the austerity measure, so the then Cuttack municipality so terminated many of the employees.
Terminated or discontinued?
I don't know, my lord, discontinued.
Discontinued.
Because of the austerity measure. So, my lord, some approach the Sahoo court and because of the direction, some are absorbed. So,
Where is the direction?
my lord, my case, yes, my case was,
You were earlier before the court again.
my lord,
Which is that? What is that order?
additional affidavit.
WP 2016.
My WPC 4051 by 2000. In the additional affidavit, I have included. So though it was quoted in the paragraph of the repetition, but for better appreciation before this honorable signature.
Where is that order?
Well, annexure 10 series of the affidavit. 40 4051 by 2000.
What is the order there?
Order dated 17/3/2009.
Go to operative procedure. Kindly read the operative procedure.
It is stated in the miscase that no supervisor post is available in automobile section of the Cuttack Municipal Corporation, and as such, Lord and Counsel for the petitioner stress that if any vacancy arises in future, the case of the petitioner shall be considered in the post of mechanic/driver. Accordingly, the order dated 17/10/2008 is modified to the extent that the case of the petitioner shall be considered for appointment, absorption, as and when there is a vacancy in the post of mechanic driver in automobile section of the Cuttack Municipal Corporation. So, my lord, as per...
No vacancy has arisen.
Yes, ma'am.
Where is that vacancy?
Yes. Vacancy, my lord, page 31 of the petition. So,
Pull out 30.
through RTI, page 31 of the petition. Supply of information is required by the petitioner. The sanctioned strength of the mechanic post is 3, light motor vehicle is 23, and heavy motor vehicle is 9 till 31/10/2013.
Existing vacancy position. That is sanction strength 1. Where is the vacancy position? Number 2. Existing
Vacancy, mechanic is 3, light motor vehicle is 10, and heavy vehicle 9.
You are which driver?
Light motor vehicle.
Who appears? First time it has come.
First time.
You take
yes answering respondent respondent number 3 Millers. Lordship see that Millers paragraph 14 of the order Millers page 23.
20?
Page 23 of the brief.
No, what he complains is, despite such an order being there, the learned single judge could not have denied relief to him, is his version. It appears to be sensible. You cannot say, earlier view was, it was for the employer to fill up vacancies or not. That view has been loosened now.
He was the contractual employee.
That's all right. There is rightly or wrongly, there is a direction. There is a court order. Whenever vacancy arises, you have to consider his case for appointment. You may consider it and reject also.
So municipality
No, only consideration is there.
will. Right.
Why notice? Again, you want to file objections.
No, Lord, Court of Municipality is there is a separate council, so that's the thing. Because what is the position right now?
Now it is corporation.
Now corporation.
Now it is
Court of Municipal Corporation.
So that duty will accrue to the corporation also.
Yes.
Right, yes.
All right. Issue notice. Learned AGA, Mr. Mohanty, on request accepts notice for the respondents. But a short point is involved.
Yes.
You will call it after 3 weeks.
Yes.
1 and 2.
And notice to OP number.
Emergent notice to OP number 3. And he accepts notice for 1 and 2. Emergent notice to OP number 3. Is the local body? Local body. OP number 3. First one. Next part. Since matter lies in a very narrow compass, and this is a subsequent legal battle, call this case in the last week of July 2025. Okay. Take this.
In this case, the petitioner challenging the inaction of the opposite party in issuing certificate relates to diploma in elementary education, though the petitioner passed in 2020.
Repeat.
The petitioner challenging the inaction of the opposite party in issuing the certificate.
Issuing or not issuing?
Not issuing.
In not issuing. You should have issued certificate to you.
Yes, I have passed in 2020.
You have passed already.
Yes.
Certificate of passing is not given to you.
Not given.
Why?
Every sincere effort I have made, but the endeavor yielded no result.
You are a court employee.
My lord?
Are you a court employee?
No, my lord. I am a teacher.
Where's the blue pink?
Is it not a single bench matter? Because
Yes.
Why it has come here?
so you should have brought to our notice. Even I didn't realize. After my lord asked, I realized. This is unless court employee, we are not assigned. I think it has to go to a single
Only
bench.
court employees alone will have this bench.
My lord, in the assignment there is a professional course. That's why I would not.
No, this is professional course means BE, MBS, MBBS, BDS, and such other professional courses.
Yes,
Whether this also comes in profession.
yes, my lord. It's a training course, my lord.
Training course is not a professional course. Suppose JOC, job-oriented course, etc. The courts have held that they are not professional
The
course.
clue would be, suppose it is not a distance learning method. So where the matters are listed?
It's a digital
If it is not, it's like our suppose conducted by Board of Secondary Education.
Any method not assigned to.
That
Single
is
bench.
See,
No, I think this will come under that
any other matter not assigned.
It comes under residuary class.
Yes.
residuary single bench.
Single. Code number 20.
26.
23.
Registry to reclassify the matter and post before the roster bench.
1897.
Huh?
1897. Item 1819.
Same order.
My-
Same order.
I don't want the
Yes.
Permitted to serve notice to the local police, my lord.
You want
So
to
what
take
is your instruction?
The instruction is the operative party, the students are in jail custody, my lord.
jail appeal?
In jail custody, my lord.
Why in jail? In another matter.
Jail, my lord, in this case, my lord, they
Even
have
after acquitted, they are inside.
they have acquitted on the offense procedure 363, 34, and 6 of POSCO Act, my lord.
Now, why they are in jail?
Jail, they are convicted in 3.
For other offenses, they are convicted.
I will permitted to take notice to the superintendent of jail for that.
The same thing. We require that when we direct for police service, so suppose they are in jail, police cannot reach the jail. The police will reach the jail. From the superintendent, it's a court order and they
Through the superintendent of jail, they issue emergent notice in a normative way, since we are told that the respondent convicts are serving a sentence for offences for which they have been convicted. First off.
Any idea which jail?
Barampur jail.
Barakot, Barampur jail.
Barampur jail, Barampur.
Okay.
Item 21.
Yes.
It's in High Court of Appeal, challenging the order of under Annex 1. It is in respect of that work charge employees. Regular.
Similar matter which we have posted it 7-7.
Yeah. That was job contract. This is work charge.
Work charged employee covered by the judgment of Apex Court, which you other day gave, na?
Yesterday.
Last paragraph of the said judgment says work charge employee is entitled to count entire service for computing the qualifying service.
But here the ground is we have not been heard. We have not been filed any counter.
No, assuming that we were heard, what is the difference it would have made?
So far the 18.3 is concerned under the Orissa pension rules. That gives him, this is not a pensionable in establishment. And apart from that, we have never been, all through, we are under the work charge establishment. For a day also, we have not come to the regular establishment. So they are getting the pension under the EPF scheme, but not under the OCS pension rules.
That aspect is not treated by the learned judge?
That has not. Furthermore, as per the OPDR Act, Appendix 3 and Part 2, they have only get gratuity also.
They will get gratuity. Not pension.
No, pension, not pension. That has also been clarified.
Not a pensionable head.
Exactly, there is no.
All right. Learned AGA appearing for the appellant submits that a very, very important factor as to pensionability of work charge establishment has not been considered by the learned single judge when it ought to have been. First off, their case is made out for admission. Issue emergent notice.
Item 22.
Formula. Here, my lord, so the Intra-Court Appeal challenging the order of the Honorable Single Judge dated 21/9/2021. Admittedly, there was a delay of 1,000 some argument.
And 1,000 days.
Yes, exactly. On depositing the cost, it has been condemned, my lord, by virtue of my lord's order dated 19/12/2024.
Cost of rupees 1 lakh.
1 lakh. Here the question is during the ban period, 1993, he has been appointed.
Similar matters we considered yesterday, day before yesterday. During the ban period was for how long it was? It was ban was there.
12/4/1993 to 97/98.
12/4/93 to
99. exactly.
No, it is beyond 99. It's sure of. The ban was, because they said they formulated the scheme that whatever existing, they will be regularized, no further.
Prior to 93, those were appointed. They may
Correct.
regular- they may-
So you are saying that it is after the cutoff date?
Yes.
That you should say.
I am appointed in 95.
You are appointed in 95 during the ban period.
Yes.
You always saying for the petitioner. Last matter also, I am appointed. So you are in the other side.
No.
You are,
My
last matter also,
friend was
I was appointed. Now you are saying I am appointed in 1995.
No.
For some time it takes to realize that.
So during ban period, whatever appointment has been made, those appointments are treated by the apex court. How? This court, there is some judgment of this court, na?
Yes, ma'am.
But some judgment you quoted other day, some Sarangi, etc.
Yes, ma'am.
Which what the court said.
No, that was posted to some other date, ma'am.
All. Which give that number, WP number.
I'll give them.
Issue emergent notice. Call this matter along with.
I'll give the number.
Yeah. Okay.
Item 25.
Yes, brother.
The respondents are not the delay of more than 2 years to file the appeal.
State's appeal.
My lord.
You are for respondent.
My lord.
Let appellant argue.
My lord.
Mr. Panda is there to conduct the case.
And moreover, similar matter.
Your friend is not there, na? Panda is not there.
I'll bring that. And the Passover or adjournment?
Any urgency? No urgency. Call week after next. Yes.
Similar writ appeal, then the same order has already been dismissed by this honorable court. It is by order dated 19th of June 2025. Can I give a Monday? Let it come on Monday so that it can be.
Why within one week? What would happen? Let it come up. Call a week after next to enable counsel, learned AG appearing for the appellant to come and argue. These matters on delay, they do not have much presidential value. It all depends upon individual case. Very case specific they are. Let us see.
In this matter also there is a delay of 2 years, Your Lordship, in 5 years.
Let us see. What is the question is not 2 years. Question is what is the explanation for the delay? Suppose explanation is very, very plausible. Then we have this say the division bench ought to have controlled the delay. Yesterday we saw that.
Then we have to see the grounds taken in the IA.
Then there can be organized delay. That is how the responsibility, fixing of responsibility, imposition of cost, as Supreme Court has been doing.
In that Suganshu case also, 1 lakh cost has been so far particularly.
That I believe Your Lordship will consider. That's that. Let us see.
Deliberately, then we can understand. But in government, this is, you know, how government would work.
In that case.
We have directive for fixing
Responsibility, individual responsibility of the officer. That amount should be recovered from them. Correct.
Then I also got an order in the Lordship. That's a similar matter. They have filed after 2 years.
Let us see. Let us see.
Item 26.
Which appearing in 26.
What happened? Paper Passover or it will be Monday?
Same order.
Same order. Same order.
Same.
I just don't.
Item 27.
I'm asking for the accused person's matter. Population action matter. Just
LCR awaited. Registry to send reminder for securing the LCR immediately. An explanation to be offered why LCRs have not reached the hands of this court from the concerned quarters. Yes.
Item 55.
Your Lordship, Lordship, the petitioner was a candidate for
His candidature is cancelled.
no, Your Lordship. Your Lordship, he was never selected, Your Lordship. In his
54 was called, 35 was called.
35, Your Lordship.
54 was this.
34
Was urgent. That is after the state appeal. That is 34, the next page, when you have got the page, you are 50.
34.
34 matter.
Okay.
It was mentioned but third it was
Adjourned. Is it adjourned? 16 July. Okay. Yes, madam.
Your Lordship, the petitioner was a candidate appearing for
For the post of?
for the post of ASO, Your Lordship, Assistant Section Officer, Your Lordship. In the year 2000, for the examination that was held in the year of 2012, Your Lordship. Lordship, opposite party, private opposite party number 4, Your Lordship. He got selected instead of the petitioner, Your Lordship, even if the petitioner had scored more marks than the private opposite
What are
party.
the score of both the candidates? Tell this.
Yes, Your Lordship. Lordship, that is in, Your Lordship may kindly turn to page 73, Your Lordship. That is the marks of the Annexure 5 series.
No, you stated it in the, when you are asked a question, don't
Yeah,
take us to
Lordship.
pages.
Lordship, the petitioner scored 271, Your Lordship. And the opposite party number 4 scored 265, Your Lordship. Your Lordship, the fact of the case is that both the candidates...
264.
265, Your Lordship.
265 out of? This is out of what number? All right. Let us see. So why
The cutoff mark in your category or the general category, any idea?
No, Your Lordship. Your Lordship, both the candidates belong to
The-
SC category, Your
The
Lordship.
advertised vacancies were there for the SC category?
Yes, Your Lordship.
How many vacancies?
Your Lordship, I'm not aware, Your Lordship.
No, you have to be, because suppose the minimum cutoff mark secured by one of these candidates is more than the cutoff in the general category, that goes to the general category.
Agreed, Your Lordship, but that is
So,
not the case here, Your Lordship.
No. For that not being the case, you have to bring the facts.
Obliged.
So that is how my lord has been asking you to give because that is how
Because
we
of-
analyze.
because of Indra Sahani, if the mark secured by scheduled caste or scheduled tribe candidate is more than the general merit candidate's performance at the minimum, then the candidature is shifted to the general category. Then you will have more opportunity of employment. Therefore, we are asking you.
Yes, Your Lordship. Your Lordship, that was submitted in the writ, Your Lordship, that was filed. I am not aware of it.
Please, therefore, because that was the basic case.
That will help you.
That will help you.
Obliged, Your Lordship.
So you go through and prepare
Yes, Your Lordship.
and get this.
Only fact is, Your Lordship, that both the candidates, Your Lordship, were SC candidates, Your Lordship.
You have said that.
And the opposite party number 4 purported himself to be also a sports person candidate, Your Lordship. That
Sports
is-
category is there.
Yes, Your Lordship. That is why he was called for the skill test and the petitioner was not called. However, during verification, it was seen that he could not produce any sports
Certificate.
certificate. However, still he was appointed.
How he was treated as sportsman?
Yes,
On what basis?
Your Lordship,
Your case is that he could not have been treated under the sports category.
that is, Your Lordship, that is with all due respect, not my case, Your Lordship. That is what the OPSC has submitted, Your
No,
Lordship.
that point you want to gain, na?
Yes.
You want to utilize that point here in your favor.
Yes.
What you say is, suppose if the OP had secured only 265 marks
Yes.
with no status as to his sportsmanship, then you should have been selected is your case.
Yes.
Who appears for the others?
Say horizontal.
Like that. Then naturally the common field will come. 265, 271. Sports preference will go. It becomes general in scheduled caste. There in the sports category. Correct. Suppose if there is another candidate, it may go to that candidate also. How many persons in the sports category?
Information was never conveyed to the petitioner, Your Lordship. He was only conveyed that since
Let us see what he
Case is a little bit different.
You
Case is a
prepare.
little bit different.
Huh?
OPSC published the mark sheet and that merit list, and that merit list has been challenged by one Abhilash boy. He is securing 72 points or something marks. He is a ST category. And thereafter, Abhilash boy has got appointment pursuant to the order of this Honorable Court, and this opinion 4, pursuant to direction of this Honorable opinion 4, has been appointed at a temporary basis. And
He has secured only 265.
Yes.
Bhanti, you are saying Boy is ST. He says that both the candidates are ST.
ST, Your Lordship.
Both are
ST.
Beg your pardon,
ST.
Yeah.
Scheduled Bogi is scheduled tribe. Scheduled tribe.
And your Lordship, and
Who is also
pursuant to the order of this Honorable Court, opinion Lordship, pursuant to the order of this.
Petition also is going so,
Pursuant to the order,
maybe
pursuant to the order of this Honorable Court, opinion 4 has been appointed as created post. So,
supernumerary post.
supernumerary post.
No,
And that order also challenged by the state also.
But then
you have also challenged it.
Yes, yes.
Which is that writ appeal?
That is the appeal number.
Then we will call this appeal along with your appeal.
Yes, yes.
That has also come in the noting, Your Lordship.
Read
Yeah,
appeal
come now.
number 1902 of 23.
It is posted today.
No.
It's not posted.
It's not tagged, Your Lordship.
So we'll call this appeal along with state appeal.
Yes.
Yes, Your Lordship.
Okay? Correct. We are told at the bar that the very same grievance is made out by the state in writ appeal number.
1902.
who has filed the IA for analogous hearing? You.
Appeal for Your Lordship.
IA for analogous hearing, IA number 508 of 2025.
Yes, Your Lordship.
You should have mentioned
Early hearing. That was not being expressed.
this.
Okay, so we should make it an order on IA.
Can be.
Order on analogous application.
1902 of 2020. I'm sorry, 508 of 2020.
Okay.
Mark.
There is another appeal filed by the state laying a challenge to the very same order.
Yes.
In
423.
writ appeal number 1902 of 2023. First up, post this appeal along with that appeal to avoid multiplicity of orders conflicting with each other. Only that. Yeah.
Your Lordship is fixing a date, Your Lordship.
Prepare. And what about OPSC? Where is your signature?
He is currently
Total number 1.
Yes.
So we'll call this matter on August 1.
No, Your Lordship.
When you want. August also you don't want to.
I've got petitions.
Your Lordship is short date, maybe.
Shorter date. Last week of July. Some date in last week of July. See that matter should not cluster. We have posted many matters now. That you should remember. Yes.
Good luck, Your Lordship.
You want to file a counter? When notice was served on you? 2024 matter it is. When we served with the court notice.
You are for OP3, are you sure you have not filed counter?
Last occasion, they were directed to file counter.
Okay, number 2 already filed, man. Okay, number 3. I have 5 minutes. So for impulse I have already filed the counter.
You have filed the counter.
Our registry has made it more. Plus, counter filed by OP3, counter filed by OP2.
You have not filed.
No.
Then you will not have right to file after 1 year.
No.
Why? Read your rules.
This is on 25 things.
Read chapter 15 of your rules. I read those rules. You can't file it at your sweet will. The time is fixed for that. It's a normative. It's statutorily normative. We'll call this matter. We'll talk next to enable respond OP number 3 to file statement of objection. Objections. Subject to paying, giving one book to the library. You have to give one book to the library.
Subject matter.
Huh? But that adjournment will not be granted free. Yes. Subject to said respondent presenting one book, Fundamental Rights by Professor Ishwar Bhatt, to the Advocates Association Library. Okay? First.
What's the fixed date?
Let propose this matter up to some date.
They come before vacation, we are in chambers. But then inform Lordship.
What we can do?